Good morning. This hearing is called to order. This is the public hearing of the City Council Committee on Labor and Civil Service. The purpose of this public hearing is to hear testimony on Bill number 180012 and resolution number 170839. I want to recognize that a presence of a quorum of committee members are in attendance. To my left is Councilman and Majority Leader Heenan. To my right is Councilman Taubenberger, Councilwoman Maria Quinones Sanchez, and Councilman Alan Dom. I want to ask the clerk to read the title of the bill for consideration today.
Amending Section 21105 of the Philadelphia Code entitled Hero Awards by increasing the amount that may be awarded to family members of firefighters, police officers, and prosecution detectives killed in the course of performing heroic deeds, and by making certain technical changes, all under certain terms and conditions.
So we want to, the clerk will please call the first panel of witnesses to testify on the bill.
Commissioner Adam Teal, Sergeant Matthew White, Ed Marks, and Nick Denofa.
We want to thank the first panel for being seated. Before you proceed with your testimony, we will ask that you state your name for the record. But prior to your doing that, we wanted to wait until you were seated, and we want to make sure that we give the undivided attention to the bill's sponsor, Councilman Alan Dom, for some comments. Councilman Dom.
Thank you, Madam Chairwoman. First, I want to thank you, Chairwoman Parker, for your leadership and for convening the committee this morning. Also want to thank everyone who has waited on the legislation I, along with my colleague, Councilman Taubenberger, have put forward. Your time, input, and support has been invaluable. This important piece of legislation increases the amount of money the city awards the immediate family members of firefighters, police officers, and prosecution detectives who are killed in the course of performing heroic deeds on behalf of the city of Philadelphia. These fallen heroes, fellow citizens, fellow Philadelphians, are performing the most selfless service to our city, putting their lives on the line day in and day out to protect each and every one of us. This legislation increases the Hero Awards to $100,000. I wish we could do more, but at least increases it to $100,000. While no amount of money can heal the grief of the families of our fallen heroes, hopefully this may provide them with some level of support. Thank you again for your time and consideration. I ask the committee for its support and for suspension of the rules to allow our first reading on our next session of council. Thank you, Madam Chairwoman.
We will ask the panel to just identify yourselves for the record.
Nick Denofa, I'm one of the vice presidents of the FOP.
Sergeant Matthew White from the Philadelphia Police Department.
Ed Marks, Local 22, firefighters.
Thank you. Feel free to proceed with your testimony.
Good morning, council members. Councilman Dom, Sanchez, Taubenberger, Parker, Councilman Heenan. On behalf of President John McNesby, my name is Nick Denofa. I'm one of the vice presidents of External Order Police. I would like to personally thank this committee for your consideration in the Heroes Award bill increase. No amount of money can ever replace a family member who was suddenly destroyed by violence. This is particularly true when the family members are public servants who voluntarily give up their lives for the fellow citizens. Nevertheless, the Fraternal Order of the Police deeply appreciates the compassion, the generosity demonstrated by this council in the creation of the Heroes Award. The financial assistance provided by the Heroes Award helps take away one burden off the shoulders of a grief-stricken family. However, as with anything else, costs have steadily risen, since the original bills passed with a fixed amount. This is the reason we are respectfully requesting a generosity increase in the amount offered. The additional funds will allow you to compensate future families with the same level of generosity you've shown the families in the past. On behalf of all of our members of 14,500 and their families, we are counting on your continued compassion and support. We thank you.
Thank you. Thank you, Nick.
Good morning, Chairwoman Parker and members of the Committee on Labor and Civil Service. On behalf of Commissioner Ross, I would like to thank you for giving the Police Department the opportunity to voice its opinion regarding Bill number 180012 related to Hero Awards. As you know, the current Hero Award set forth in City Code Section 21105 is $50,000 awarded to the surviving spouse or dependent children or dependent parents of every firefighter and police officer killed in the course of performing a heroic deed. The payment of this amount is currently $1,000 stretched over a 50-month period. I'm here today to fully support increasing this award to $100,000 and increasing the monthly payout to $2,000 for a 50-month period. The fear of police officers, and I'm sure the same is true for firefighters, is not the danger we face every day. The brave men and women of our police and fire departments run towards danger willingly to serve and protect. Rather, the top fear of these men and women is not being there to support their families. To the families, money can never replace the heroes we lose, but to those police and firefighters on the street today, this bill will show that the city cares about them and, equally important, about their families. So on behalf of my commissioner and the police officers, I would like to thank council members Dom, Taubenberger, Parker, O, Squilla, Heenan, and O'Neill for sponsoring this bill. This concludes my testimony, and I'd be happy to answer any questions.
Thank you, Matthew.
Good morning. My name is Edward Marks. I'm president of Local 22 of the International Association of Firefighters and Paramedics Union here in Philadelphia. And I'm here today to testify in support of Bill number 180012, which looks to increase the death benefit awarded to our members of our union, among others that are killed in the line of duty. I would like to take a moment to personally thank once again Councilman Dom Toppenberger, Councilpersons Quinones Sanchez, Parker, and Bobby Heenan for sponsoring this bill. As you know, this bill would increase the award bestowed upon our city's heroes to $100,000. I ask you, what is life worth? I don't think anyone can truly answer that question because life is priceless. I have been blessed with the fortune to know many of these people over my 30-year career in the fire department as I ascended through the ranks to battalion chief. A lot of the members in our department who died in the line of duty. Personally, my first assignment as a battalion chief was deputy director of training up at the fire academy, and our duties up there was to handle all the funerals when it comes to line of duty deaths. So I was on the funeral team for 12 years, so I've been through this many, many times before, and I know how it affects the families and the loved ones that are left behind. That's just a little personal thing that I added in there. The individuals that make the ultimate sacrifice in the performance of their duty to their fellow citizens are special and are precious gem to our citizens of Philadelphia. As a city and a citizen, I feel it is our duty as public leaders to show our appreciation for those heroes who sacrificed by supporting their families that are left behind. Once again, in my career, I've known dozens of firefighters who have lost their lives. It never gets any easier, and the sadness and uncertainty that follows also presents a problem. We as a city and a union are still reeling from the loss of Lieutenant Matt Latournelle, who was posthumously promoted to captain in January. By supporting Bill 180012, I believe that we are showing our first responders that we value their service and dedication, and we will be there for their loved ones should something tragic befall in the line of duty. I appreciate your time and thank council for all your support of our members. Thank you.
Thank you. Commissioner, it is an honor to have you here, and because you've just arrived, we'll just ask you to state your name for the record before your testimony.
Thank you, Councilwoman. Adam Teal, I'm the Fire Commissioner for the City of Philadelphia. Good morning, Chairwoman Parker and members of the Committee on Labor and Civil Service. I am Adam Teal, Commissioner of the Philadelphia Fire Department. I am here today to testify in support of Bill Number 180012, sponsored by Council Members Dom, Taubenberger, O'Neill, Parker, O, Squilla, Heenan, and O'Neill, which seeks to increase the amount awarded to family members of firefighters, police officers, and prosecution detectives killed in the course of performing heroic deeds. The HERO Award, which currently stands at $50,000, was last increased in 2017. Thank you for that as well. The cost of living continues to rise, and Bill Number 180012 would help surviving family members through a difficult emotional crisis by alleviating some financial concerns. The increased funding would signal strong support for grieving families. Firefighters have been serving Philadelphia for more than 280 years. They risk their lives every day to protect the residents of this city. When they make the ultimate sacrifice, the city should honor that loss and support the family members left behind. Our colleagues in law enforcement deserve the same recognition. Thank you for inviting me to testify in support of this important legislation. I would be happy to answer any questions, and I also want to publicly thank all of you for your support during our recent loss of Lieutenant, now Captain Matt Latorno. Thank you.
Thank you. Thank you, Commissioner, and thank you all so very much for your testimony. I want to ask, is there anyone else here who is interested in testifying on this bill? Anyone? To my colleagues, any comments? Councilman Toppenberger.
Thank you, Madam Chair. I just want to thank you all, the first panel, for your service, as well as your members and your fellow workers, both in the police, fire department, and first responders. I am also very indebted to Councilman Dom for the leadership here as well. And there's no dollar amount you could ever put on a human life, but in some ways is a small matter to honor in many ways a horrific loss to a family. It is at least something we can do and can always count on us for your support to support your needs. So thank you again, and glad to be voting aye on this.
Thank you. Thank you. Well, this concludes the public hearing. We will now go into a public meeting to consider the action to be taken on the bill heard today. With that being said, the chair recognizes Councilman Dom for a motion to Bill Number 180012.
Thank you, Madam Chair. I move that Bill Number 180012 be reported from this committee with a favorable recommendation, and further move that the rules of council be suspended to permit first reading of this bill at the next session of council.
Second.
It has been moved and properly seconded that Bill Number 180012 be reported from this committee with a favorable recommendation, and further moved that the rules of council be suspended to permit first reading of this bill at the next session of council. All those in favor of the motion will signify by saying aye.
Aye.
Those opposed? The ayes have it, and the motion carries. Bill Number 180012 will be reported from this committee with a favorable recommendation, with a request that the rules of council be suspended to permit first reading at the next session of council. Thank you all so very much for being here.
Thank you.
This committee shall now resume its public hearing to hear testimony on resolution number 170839. The clerk will now read the title of the resolution being considered today.
Authorizing City Council's Committee on Labor and Civil Service to hold hearings regarding the state's recent legalization of medical marijuana and to address questions related to medical marijuana's potential impact on employers and employees in Philadelphia.
Before we open, let me just start by saying that, as many of us already know, medical marijuana dispensaries opened in Pennsylvania in the past few months, and some of them in recent weeks. And while there have been some initial hiccups around some of the implementation, it is our hope that we see more Pennsylvanians benefiting from medical marijuana and are being served and will be served on a daily basis. Before we get into the meat of this hearing, I want to make clear that the purpose of this hearing, and I want to make sure that we are very clear about this, the purpose of this hearing is not to debate the pros and the cons of medical marijuana. That conversation has already taken place in the public and in the General Assembly. Overwhelmingly, it began when I was a member, was proud to to support it then. Instead, today's hearing is regarding what happens after the implementation of medical marijuana and it's fully implemented and running in our state. I wanted to state for the record that 29 other states, plus the territories of Guam and Puerto Rico and the District of Columbia, have laws regulating the use of medicinal marijuana. Many of these states are several years into the implementation of their medical marijuana legislation, and during this time, there are various legal questions that have been raised, and some of which concern the overlap of the issue of medical marijuana and employment. Oftentimes, these legal issues arise when an employer refuses to hire or terminates an employee due to a positive drug test, but that employee is a medical marijuana user. So during today's hearing, you are first going to hear from our Chamber of Commerce, and that is not by accident. I want to state for the public record that I've been very clear regarding this hearing that it would be my hope that the public sector would help to lead in this effort in developing any potential legislative prescriptions to address this issue relative to employers and employment, and that we work hand in hand with the private sector along with government to make those things happen. We are then going to hear from representatives from our city's Human Resources Office and the Human Relations Commission. The Office of Risk Management is also here if any relevant questions arise. I also want to note that for this information session, and I want you to just charge it to my head and not my heart if I screw up your last name, George. George Vogel? Vogeli of Cozen O'Connor is present today. He will be presenting along with Josh Horn, and they will literally get into the nitty-gritty details about the Medical Marijuana Act and its legal implications. We will hear from Dr. Richard Kahn, a forensic toxicologist who is frequently called as an expert witness in court. Samantha, thank you for making sure he got here today. Rounding out the hearing, we'll be hearing from our district attorney's office as well as a representative from organized labor, which is extremely important, on the law's potential impact on workers in the city. Our goal for this hearing is to understand the full implications of the Medical Marijuana Act on employers and employees in the city of Philadelphia. In addition, we want to explore what the city can do to protect employees throughout Philadelphia from being wrongfully terminated if they are medical marijuana patients. We may determine that our best course of action is to make an ask of the state of Pennsylvania, our General Assembly, to further improve the Medical Marijuana Act. But if there is anything that this body, the City Council of Philadelphia, or our District Attorney's Office can do to protect employees, the goal of this hearing is for us to become informed today and for us to act from a position of information based on human resource professionals, those from the legal industry, along with government. So I want to thank you all so very much for being here. And will the clerk please call up the first panel?
Yvette Nunez, Pedro Rodriguez, and Rue Landau.
Excuse me, before the panel begins, let me note that Vice Chair Councilman O'Neill has arrived. And Councilman O'Neill, we want to thank you, along with Councilwoman Helen Gim, and want to ask if either of you have any comments. Although we have started the hearing on the testimony for the resolution, if you wanted to make any comments about the prior bill that was recently passed from committee relevant to the Heroes Award, please feel free to do so.
Just that I'm in favor of any increase we can possibly do. There really isn't a highest amount in my mind for what that bill stands for. Thank you.
Councilwoman Gill?
Yes, also expressing my significant support for the awards and thanking the bill's sponsor and this committee for moving it forward.
Thank you. Thank you. Please, as you begin your testimony, state your name and identify yourself for the record.
Good morning, Chairwoman Parker and members of the committee. My name is Yvette Nunez. I'm Vice President of Civic Affairs for the Chamber of Commerce for Greater Philadelphia. I'm here this morning to read formally into the record a letter that we shared with the chairwoman and can make available to members of the committee as needed. I do ask that you excuse me as I have to leave after submitting this testimony, but am available at your convenience should you have any questions or follow-up. On behalf of the Chamber of Commerce for Greater Philadelphia, I am pleased to provide information regarding the effects of the law allowing for medicinal marijuana dispensaries in the Commonwealth of Pennsylvania. While the Chamber did not take a position on the legislation, following the law's passage, we did hold a workshop for human resource professionals to discuss the law and its effect on employers and employees. Since the federal government still considers marijuana a Schedule I substance, there was concern expressed by the program participants about the ramifications of not complying with federal law. We can also offer that there was concern expressed about drug use policies and substance use for employees in critical positions or jobs that require the use of machinery or vehicles. As the effects of this legislation are felt amongst the employer community, we will continue to monitor the reactions and concerns of our members and share those with this committee. Thank you.
Good morning, Chairwoman Parker.
I'm sorry, could you, 1 second. We know that the chamber, Yvette has to leave, but before she leaves, if there were any questions that you wanted to ask of her. Okay, Yvette, thank you so much. Just wanted to make sure we did that for the record.
Thank you again. Good morning. My name is Pedro Rodriguez. I'm the Director of the Office of Human Resources for the City of Philadelphia. I'm pleased to provide testimony on resolution number 170839 regarding the recent legalization of medical marijuana in Pennsylvania and its potential impact on employment matters for workers and employers in the City of Philadelphia. I will limit my remarks to the considerations of the potential impact on our city workforce and operations of city departments. Almost a year ago, the Pennsylvania legislature joined 25 other states in the District of Columbia in legalizing the medicinal use of marijuana. While other states, most notably Colorado, California, Alaska, and Oregon, have also legalized the recreational use of marijuana, the use of marijuana in any form it is still prohibited under federal statutes. Due to this fact, conflict between state and federal laws with respect to employment matters has already occurred and will continue until federal courts decide cases or Congress changes the law. The challenge for us as employer is how to balance the medical needs of our workers as set by the Pennsylvania's Medical Marijuana Act with the constraints of federal law and policy. While Pennsylvania's medical marijuana bill states that, quote, no employer may discharge, threaten, refuse to hire, or otherwise discriminate or retaliate against an employee regarding an employer's compensation, terms, conditions, location, or privileges, solely on the basis of such employee's status as an individual who is certified to use medical marijuana. It is also silent on federal law requirements. Two federal laws which the City of Philadelphia must comply with are the Drug-Free Workplace Act of 1988 and the Omnibus Transportation Act of 1991. The Drug-Free Workplace Act requires that all federal grant recipients and federal contractors adopt a zero-tolerance policy in their workplace and certify to the federal government that their workplaces are drug-free. The Act also requires that covered entities make an ongoing good faith effort to maintain a drug-free workplace by doing such things like educating their employees on the employer's workplace drug policy and notifying employees of all penalties that may result for drug use violations. The Act does not, however, require that employers conduct mandatory drug tests. It should also be noted that even if an employer is not required to comply with the Act, employers can still institute a zero-tolerance policy for those workers in, quote, safety-sensitive positions. A safety-sensitive position generally is one in which an employee is responsible for the safety of herself or himself or others. Examples of positions that would be considered safety-sensitive are those that involve driving or the use of machinery or public safety, among many others. Additionally, the Omnibus Transportation Employee Safety Act requires that all employers drug test employees whose duties require a commercial driver's license or CDL. Consistent with federal laws, the city drug and alcohol policy, which applies to all non-uniform employees, prohibits the possession, manufacture, transfer, distribution, dispensing, sale or use of prohibited substances or alcoholic beverages while on city premises, during work hours, or while operating a city-owned or leased vehicle or personal vehicle when conducting city business. This policy was negotiated with both ASBE District Council 47 and District Council 33, and is part of the collective bargaining agreement the city has with both unions. The city's policy requires employees to disclose if they are prescribed medications that might alter their psychomotor skills or ability to function, and they may not operate machinery or motor vehicles while taking this type of prescribed medications. Pennsylvania's Medical Marijuana Act does give the employer the authority to determine the types of tasks an employee should not be permitted to perform while being prescribed medical marijuana. And in this way, it's consistent with the city's drug and alcohol policy. For example, the city has identified several non-uniform titles that require drug testing, and the city's policy also requires that all non-CDL title employees participating in a drug and alcohol treatment program due to disciplinary actions be subject to random testing. It is also important to note that Pennsylvania's Medical Marijuana Act does not require that an employer make an accommodation for the use of medical marijuana on, quote, the property or premises of any place of employment, unquote. However, recently, the Massachusetts Supreme Court found that an employer does have a duty to accommodate an employee's use of medical marijuana, and this is the first state court that has ruled in such a favor. Most other courts in Oregon and California has done otherwise and sustained the federal law. As you can see, balancing federal and state law with the medical needs of our employees is not easy, but we welcome the opportunity to be part of this important conversation. Our hope is that constructive dialogue will lead to policies that safeguard the rights of our employees to receive the best possible course of medical treatment as determined by a licensed physician or medical provider, and the city's responsibility to comply with federal law and to maintain the general safety of our workers and the public we serve. Thank you for this opportunity. I am happy to answer any questions from the committee.
Thank you for your testimony. Let me just note for the record that for all of the panels who will be testifying, we do have an actual copy of your testimony. If you decide that you want to summarize your testimony, I want you to feel free to do so. I do know when you're acknowledging sort of legal acts, you want to make sure that you get those facts accurate and entered into the record. We will make sure all of the testimony is included. And we may be asking after the Human Relations, the Commission on Human Relations testify, we may be asking our next panel to scoot up, because I'm sure questions that may be posed to this panel, you can also be of assistance to us all. Thank you. Please proceed.
Great, thank you. Thank you, Chairperson Parker and members of the Labor and Service Committee for giving me the opportunity to testify on resolution number 170839 to examine medical marijuana's impact on employers and employees in Philadelphia. I am Rue Landau, Executive Director of the Philadelphia Commission on Human Relations, the agency that enforces our city's civil rights laws, particularly the Fair Practice Ordinance, Chapter 9-1100 of the Philadelphia Code. On April 17, 2016, Governor Tom Wolf signed the Medical Marijuana Act, which allows for the use of medical marijuana for certain prescribed conditions in Pennsylvania. Depending on the health condition and its effects, a certified medical marijuana user may fall within the protected category of a person with a disability under federal and local, state and local law. In that instance, it is essential that the employee establish and document their medical condition as a disability. The law governing this new area is complicated. Under the Pennsylvania MMA, marijuana is not an illegal substance when the individual is certified for medical marijuana use, and the drug is taken under the supervision and care of a licensed healthcare professional. However, under federal law, under the Controlled Substances Act, it categorizes marijuana as a Schedule I drug and considered as a drug with a high potential for abuse and no medical use. State marijuana laws vary. Currently, 29 states and Washington, D.C. have enacted legislation and regulating some form of medical marijuana use. Within this conflicted legal environment, employers and employees retain their rights and responsibilities under other federal legislation, including the Americans with Disabilities Act, the Family Medical Leave Act, as well as the State Human Relations Act and the city's Fair Practices Ordinance. Even within the Pennsylvania MMA, many rights and responsibilities contrast. The law, as Pedro already indicated, contains specific anti-discrimination provisions for the workplace, namely that an employer may not terminate, threaten, refuse to hire, or otherwise discriminate against an employee solely on the basis of the employee's status as a certified user of medical marijuana. But at the same time, it does not require an employer to make accommodations for the use of medical marijuana while the employee is working, especially when the use is in violation of federal laws, such as Department of Transportation regulations. In addition, an employer may discipline an employee for being under the influence of medical marijuana, or if the employee's conduct falls below normally accepted standards for the position. While there have been some federal court decisions on the topic, none have been of precedential value. To date, no federal court has determined there is a duty to accommodate medical marijuana users under the Americans with Disabilities Act. In fact, multiple cases have been decided in support of the employer's rights under the ADA. However, again, as Pedro noted, in July of 2017, in the first of its kind ruling, the Massachusetts State Supreme Court decided a case in favor of an employee who was fired after testing positive for marijuana when she used the drug medicinally to offset the painful effects of her disability. The new reality of legal marijuana will continue to challenge employer drug testing and performance policies. While the employer has the right to do so, the termination of an employee for failing mandatory drug testing effectively denies the employee with a disability the opportunity of a reasonable accommodation and therefore could be considered disability discrimination. In Philadelphia, where legally sufficient, we will accept and investigate these cases under Section 9-1103 of the Fair Practices Ordinance as cases of alleged disability discrimination. In the meantime, we await regulations from the Pennsylvania Department of Health, which they were obligated to have promulgated within 18 months of the law, but have not happened yet. Thank you for the opportunity to testify, and I'm happy to answer any questions. Thank you.
Thank you for your testimony. I am now going to ask George, Joshua, and Dr. Khan to come forward and just join the panel. Don't move, you guys.
Okay.
I want them just at the table while their panel has not officially and formally started. I wanted them here just in case when committee members are asking questions that they could all be helpful. I am just going to start with one in particular to ask. One, is there precedence in any of the other states that have legalized medical marijuana? I don't want to talk about the recreational use, just what we have established here in Pennsylvania. Is there a precedent for a Human Relations Commission and or the HR department for a municipality to develop some sort of the do's and don'ts, a fact sheet regarding medical marijuana use and employees? Is there precedent for that? Is that something that you have considered developing? Because from my perspective and very practically, when I think about city employees and quite frankly, other employees, I'm thinking about home health aid workers in the city of Philadelphia, security officers, and particularly many of the lower wage workers. If there is a guide, right, that simply gives you a checklist of what you can or what is recommended that you can and can't do, then that provides some guidance. Or is that a direction that you're moving in legally with the city because of liability, be sort of counseled by its law department to not do that because of a fear of liability? Tell me what our thinking is regarding that issue.
Do you guys want to start?
I can.
Okay.
Josh, thank you, Chairwoman. Joshua Horn from the law firm of Fox Rothschild. Just for the record, I co-chair our cannabis law practice group. I also chair the subcommittee of the Philadelphia Bar on the employment law section under the medical marijuana and hemp law section on the Philadelphia Bar. So there's not a lot of precedent, but there are a handful of cases that have dealt with this. And actually the most recent case, which is probably the closest to what we have here in the Commonwealth of Pennsylvania, is a case out of Rhode Island, which was decided in May of this past year. And the important thing there is the court in Rhode Island said that the federal law did not preempt Rhode Island's medical marijuana statute, and that the employer's discharge of an employee for her medical marijuana use was a violation of the state's medical marijuana law and the state's civil rights statute. And the important thing about that case is called Callahan, Callaghan versus Darlington Fabrics. And the key thing, the takeaway for this panel from that case is that the anti-discrimination provision in the Rhode Island statute mirrored the anti-discrimination provision that's in the Pennsylvania Medical Marijuana Act. And that's the closest, at least from our context, of what we've seen. There's another case from August of 2017, decided actually by a federal court in Connecticut, and that's Nofsinger, which is N-O-F-F-S-I-N-G-E-R versus SSC Niantic, N-A-I-N-T-I-C, operating. And the significant part about that case is there was a job offer was withdrawn after the candidate tested positive for marijuana, but the district court, importantly in that case, held that the Federal Controlled Substances Act and the ADA did not preempt enforcement of Connecticut's state marijuana law, and so therefore the dismissal was improper under the state medical marijuana statute. So those are probably the two most recent cases that have dealt with it. George may have some more to add to that, but there's not a checklist that I think that we see.
Council, thank you very much again for the opportunity to testify here today. Most, if not exclusively, the legislation and activity on this has been on the federal level, on the state level. Mm-hmm. And there has been very little in terms of city ordinances or city regulations in this area. It's such a rapidly evolving area. I don't need to tell all of you that 5 or 10 years ago, if you told me we'd be sitting here talking about this, I would have not believed it. The area has evolved so rapidly. So I think many cities across the country are grappling with this in light of their state legislature's efforts to move forward and legalize medical marijuana regime. So I'm not familiar with any particular cities that have really gone out and provided detailed ordinances or detailed regulations as of yet for their employees. At this point, we're still waiting for the state to give us its regulations, after which I think we'll be in a better position to determine what regulation may be appropriate at the local level.
If I may add, I mean, currently we will bring the individual under our current drug and alcohol policy because it addresses this, although it did not foresee medical marijuana specifically. It does say that as an individual is prescribed marijuana, depending on the title that the person holds in the city, that person will approach the human resource office in that department or the ADA person and ask for an accommodation while it's being used. Having said that, you know, it depends on what the title is. If you work at the airport, there's a problem because, you know, federal law and policy trumps anything else that we can do here. It is also interesting to note that the Pennsylvania statute, unlike places like Oregon or California, you know, in California was a referendum that was passed to legalize medical marijuana. When it was taken, when individuals were dismissed from employment because having been found positive for marijuana, the state court in California said that the voters did not intend to interfere with employment law, therefore the dismissal was upheld. And the similar case in Oregon happened too. And we're getting now conflicting results from different state courts around the country. So unless Congress acts, it probably end up in the Supreme Court to make the final determination.
So let me just state for the record that I know and often have some banter with electeds in other regions that they don't believe that Philadelphia is usually on the cutting edge of most, but I firmly, disagree, and I'm sure all of my colleagues would too. But I would like to ask Mrs. Landau, particularly for the Commission on Human Relations, if we would consider, we Commission on Human Relations, along with the City of Philadelphia, while the state law is continuing, state regs continuing to unfold, and I just read an article, that the discussion relative to the legalization of the recreational use of medical marijuana, is being recommended by a committee in Harrisburg, and I understand is being given serious consideration as they move forward. I would ask that from a civil rights perspective, that we get brain trust from our chamber, from our legal community, the Bar Association, the Barristers Association. I know we're going to hear more when we hear from the District Attorney's Office, but that Philadelphia, to the best of its ability, attempt to take a proactive role in, even if they can't be considered formal recommendations that are legally binding, come up with some sort of rubric that we can provide, not just to the City of Philadelphia's employees, but to residents, who are even employed in the private sector. Again, I want to just, because someone will leave here today saying that the City of Philadelphia is about to work on, developing regulations for, the use of medical marijuana. That is not what I am saying. We are just talking about some sort of guide that we can proactively, publicize, like a public service announcement or advisory for workers in the City of Philadelphia. And for all of the members of council who are here, I know each and every one of us at different times can acknowledge having received a call from a constituent who they don't have to be employed by the City of Philadelphia, but in the private sector, who was terminated, who did not get selected for a job, and they call you as an elected official saying, is there anything that you can do to help? And we want to be able to say that our guidance from a proactive perspective is being shepherded by not just state government, because sometimes we can get it wrong, and local government can too, but the private sector, the legal community, along with human resource agencies and civil rights agencies, across the board. So if that's something that you could go back and maybe convene a group on from a civil rights perspective, that would be helpful.
Absolutely. And for us, it's all about the underlying disability and what somebody needs to take or to do in order to accommodate that disability. Just as a side personal note, my father has significant disabilities, and we just recently started giving him hemp oil. It has reduced his anxiety and reduced some of the pain associated with his disabilities. It's made a significant change. He's just happier every day. Obviously, too old to work and also not fit to work. But you would just hope that the slight changes that happen with him, if that happens to just some other employee who has to overcome a disability and go to work every day, it does not produce the high. It's not making somebody fully impaired. It's just offsetting some of the conditions that people are facing in order to get them to go to work every day and to make a living for themselves and their families.
Well, we're going to hear from Councilman O'Neill, but I just want you to note that your public testimony relative to your personal experience with your father is the perfect example about why some guidance for the public is necessary, because there is someone who is listening to this testimony who appreciates what you just said, but they said her perspective is subjective. Right? That's her perspective. That's why I think it is so important that we be guided, right, in a very structured and formalized way. And I appreciate your sharing that. The chair recognizes Councilman O'Neill.
Thank you, Madam Chair. I think the best thing we can do from a city standpoint, raising the issue today through this resolution, but since the state hasn't passed regulations, is weigh in on commenting on what you would like to see, what you hope to see, not just human relations, not just personnel, human services, but the Bar Association that has a chapter on this, and anybody else, the DA's office, we're the big dog in the state. We have more apparatus than anyone else. And if the state is still mulling over regulations, it might be good to share experiences, learning with them. Unfortunately, it was raised, that the federal government could make this a lot easier, but they can't agree that it's Wednesday. Okay, and at least the state. Well, it may not be the most effective state legislature. It really shines in comparison to our federal Congress. So there is a chance there, and it looks like what we're hearing is it's going to come down to finding ways to, in this period where the federal government's saying one thing and kind of leaving the states alone, I think courts are going to bend over to find reasons to side with the patient in these cases, and that would be enforcing the state regulations and the state law, and kind of just letting the Fed finding reasons not to pull down the sledgehammer of some federal statutes that haven't been enforced for a long time. Thank you.
Thank you, Councilman O'Neill. Councilman Heenan.
Thank you, Madam Chair, and I want to thank you for bringing this attention to the general public, with this resolution, because I think it is important, through the testimony that we've heard here today and through the constituencies that, we all represent as a policymaker body, that, regulations and the way, we have to determine ourselves, as the councilman was just alluding to, when the federal government is not making those tough decisions, and there's a lot of gray area, when it comes to regulations, that we do keep in mind, first and foremost, the patients and its but unintended consequences on the workers and the workers' rights of the Commonwealth. You've heard from the chamber, we're hearing from HR in the city of Philadelphia and council members, but there are workers who are protected by collective bargaining agreements, things that need to be negotiated, things that policies that are in place with drug testing currently and how this interacts and blends. So now is the time to actually bring these conversations to light when when the regulations are being formatted and how it's going to be implemented and enforced, because it could have a critical unintended consequence on workers just going to work every day who are receiving treatments and have another option in front of them that they chose for themselves between patient and doctor privilege. So I thank you for that, and I urge that we figure out ways to convey to the Commonwealth for these regulations for our own municipality and the people that we represent. So thank you.
Thank you, Councilman Heenan. Councilwoman Gimm?
Yes, thank you very much, Madam Chair, for this important hearing. I think that I'm going to echo the comments of my colleagues earlier, but I also want to thank all the panelists. I think that it is very true that 5 years ago, in the terms of employment law, it would be hard to imagine that we're in a state where we can talk about legalized marijuana, and also how it has assisted people working today and dealing with, different illnesses and as well as disabilities in the workplace. I mean, one of the things that I think is important at this time is that it is really, I think a lot of this is going to, rather than look at this issue right now as just sort of legal wrangling between state, municipal, and federal authorities, a lot of the time that we've got right now is to educate our employers and our employees about the issues that are before us. We've worked a long time in the city of Philadelphia to get into an attitude of decriminalization around health issues in particular. And employers and employees' understandings that health issues ought not to be criminalized, that people need supports and how to help people become their most full self by being able to work in the workplace, no matter their particular situations, abilities to recognize that people can manage illnesses and different abilities in the workplace is a really key factor. I also want to echo the chairwoman in saying that this is a particularly important time for us to highlight and emphasize the Fair Practices Ordinance, to emphasize civil rights and liberties, to understand the role of, in particular, disability rights, healthcare needs, mental health supports, particularly in the workplace. I think it's an extremely opportune moment to really exercise on that, because people are looking for answers. They want to understand boundaries, but there's also growing awareness that you can't just take a blanket approach right now. There are complications around how we are looking at particular, controlled substances, and it's also really important for us just to keep on the issue of diversity in the workplace, and particularly people being able to manage and work at their fullest capacity while they're dealing with assorted issues that are very prevalent across the city of Philadelphia and across the nation. So I want to thank you for that.
Sure, thank you. Let me I want to thank the first panel for their testimony, and I do want to note for the record that the difference in federal law versus state law as it relates to this issue is very obvious to us all, right? But we are also, fully aware of the federal government's verbal, because we haven't seen much formal action relative to rolling back some considerations that were allowed to states, that although the federal classification of the drug had not formally changed, considerations that were allowed under the past presidential administration, we did hear some comments, read some articles, statements that were made by our Attorney General relative to this issue. And so while we know we're waiting for clarification from state law, and the Commonwealth is mulling how, as it moves further, to address this issue. And as Councilman O'Neill, I think, aptly stated, we wait to see if the federal government can actually get it right. The fact of the matter is that it is legal here in the Commonwealth of Pennsylvania, and as Councilman O'Neill stated, we are the big dogs with a population that has a highly concentrated constituency attempting to seek the benefits that you so aptly described that your father receives from the medicinal use of medical marijuana. And so that is the reason why we thought it was extremely important to bring up this conversation about the unintended consequences of what we think was a move in the right direction. So I want to thank each and every one of you for testimony. Ask that the second panel just sort of move in so you can provide your testimony. And we are also, in a very unconventional way, because we think that the third panel may be able to add value if this panel is offered any questions. So we're also going to, as George and Joshua and Dr. Khan take their seats, we want to ask Mike Lee, who is the Assistant District Attorney and Interim Director of Legislation and Government Affairs for the Philadelphia District Attorney's Office, to also please come forward. And Samaria Harris, who is a ICU nurse at Einstein Hospital and a board member for the Pennsylvania Association for Staff Nurses and Allied Professions, if she would also come up. And gentlemen, if you can now just formally identify yourselves for the record as the second panel.
Richard Cohn. I'm a forensic toxicologist with Drug Scan Incorporated.
Joshua Horn, partner of Fox Rothschild here in Philadelphia and chair of our cannabis law practice group.
George Vogley from Cozen O'Connor, also a member of our firm's cannabis practice law group.
Ask our two attorneys if you two can begin testimony first.
Thank you.
And I guess we'll be turning our attention to the screen.
Yeah, we were good enough to give the committee a PowerPoint, which we're going to go through rather quickly. We'll highlight some of the main points. I think, Chairwoman Parker, you really hit the nail on the head. We have a lot of uncertainty at the federal level. I think the analysis is to start with the understanding that the Controlled Substances Act still characterizes cannabis as a Schedule I substance, which means, paraphrased, that it has no viable purpose and it's highly addictive or subject to abuse. But however, the important thing to understand is, ever since California went medical in the mid-90s, the federal government has taken a more or less hands-off approach. And in 2014, during the Obama administration, there were a series of memoranda that were put together by Assistant U.S. Attorney James Cole, which are subsequently known as the Cole Memoranda. And the Cole Memoranda basically said as follows: we, Department of Justice, are not making it a priority to prosecute entities or people in the medical marijuana space as long as they are doing it pursuant to a state regulated program. And then there were some exceptions to that, but so that's the universe that we've been living under. That's the universe where all these states have come forward and changed their laws. And now in January 4 of this year, Attorney General Sessions ripped that up. And so there was a hue and cry that the sky's falling for medical marijuana here in Pennsylvania. Wasn't even live, so to speak, at that point. And our analysis is that really, you have to understand that the Cole Memo was only a policy statement. It was not a rule of law. It was not an act of Congress. And by Attorney General Sessions ripping it up, all he's basically saying is not a priority the priority not to prosecute is no longer there. But that doesn't mean they can prosecute, and here's why. There's no money. The federal government, since 2014, there's been a series of amendments to the spending bill, originally known as the Rohrabacher-Farr Amendment. Mr. Farr has subsequently retired, so now it's Rohrabacher-Blumenauer. Basically what that says is the federal government is not going to fund the Department of Justice to prosecute state-regulated medical marijuana programs. So that's really the kind of the federal overlay that you have. It is a little bit murky, but until there's money for the Department of Justice to prosecute, it's not going anywhere. And notwithstanding the current budget battles that we've been seeing on the federal level, this has still remained. But with that being said, there's still an issue if someone's subject to federal laws, which George will touch on in more detail, such as the ADA, Department of Transportation, or Drug-Free Workplace Act. You still have those issues that you have to deal with, notwithstanding the state laws on the subject. So just to kind of go over some additional things. So there are 9 states that have a recreational program, and subsequent to the creation of this slide, in the last 8 weeks, both Vermont and New Hampshire have legislatively approved recreational marijuana or adult use marijuana. They don't have regulations in place, but it certainly shows the trend that we're dealing with, that this is not going away. And then here are the 29 states, now we don't have Puerto Rico or Guam on here, but that have a medical marijuana program. And even, if you think about some of the states that are thinking about coming online, you have Utah, which is maybe one of the next states to come online, so not exactly the bastion of liberalism, but I think it's important that there is a recognition on a national basis that there are people out there who will get a benefit from medical marijuana. And statistics show that 94% of people in this country support medical marijuana. And so notwithstanding the uncertainty of the federal government, I don't think that we have to be concerned that anything's going to happen to our program anytime soon. So let's talk about what you have to do in Pennsylvania. First of all, to get a medical marijuana card, you have to be under the care of a physician who's registered through the Department of Health, and that physician has to have completed a training program through the Department of Health. The physician then must certify the patient as having one of or more of the 17 serious medical conditions for which you can get medical marijuana. And that is then certified into the system so the state knows it through a computer system that is in place. Next, the patient has to apply to get an identification card, and the important thing, I think, from an employment standpoint that people have to understand is that card is only good for 1 year. So it's not a perpetual get-out-of-jail-free card, so to speak. It has to be renewed every year. And the other important thing is you can only purchase medical marijuana through a licensed dispensary, which, there are 6 regions throughout the Commonwealth and where they'll be dispersed throughout those regions. And the other important thing, it's not, you have to, in these dispensaries, have either a physician, if it's the primary location for the licensee, on staff when it's open, or a certified licensed physician, pharmacist. So the forms of medical marijuana that you can currently get are pills, creams, oils, liquids, tinctures, and vaporized form. You currently can't get leaf, or what otherwise known as, what people would understand, smokable marijuana other than vape. Now, this past week, the advisory committee under the Medical Marijuana Act at the Department of Health has recommended to the Department of Health to allow leaf to be sold so it can be smoked, because some people prefer to do that as opposed to one of these other methods. There was a lot of concern with children over edibles. Edibles cannot be sold, although you can create an edible on your own if you're a part of the program, but you can't sell it. Here are the 17 serious medical conditions, and a couple of important things from an employment standpoint. These conditions cannot be changed unless it's by statute. It's defined by statute. And if you look at some of them, I think you have to understand that a lot of these are life-ending events. They're not, it's not like the criticism that California had for its medical marijuana program was all of a sudden everyone in California had insomnia overnight because it was so liberal. Here it is a very highly regulated system, and many of these ailments are you're only going to really get palliative care or pain relief from those treatments. So there's a distinct possibility a number of people who have any of these 17 ailments wouldn't be in the workforce anyway.
Thank you. I think with that, I'll take the next slide here. Speaking specifically about Pennsylvania's law and the employee protections it provides. First, let me just take one step back and explain to council that really there's 3 distinct groupings that states have fallen into with regard to the protections they provided employees in their medical marijuana statutes. There's a first group that really has no employee protections in their statutes. There's a second group that has what we're calling limited protections. And then there's this third group that has enhanced protections. Pennsylvania really falls in that second category, at least right now, what we think, where we're providing a protection, a limited protection to individuals that says you cannot discriminate or retaliate against a medical marijuana user solely by virtue of their status as a medical marijuana user. The statute goes on to say that nothing in the act shall be construed in any way as to require an employer to violate federal law. And as we've already heard today, there are a number of federal mandates that require drug testing of employees. And when this statute was first passed, the advice we were giving many of our employer or clients was that you still must abide by federal drug-free workplace laws, zero tolerance policies on drug use is still okay. You can discipline or terminate an employee for failing a drug test. And of course, you can still discipline an employee who's under the influence. Our advice on that is starting to change in light of what's happened in some other states, and I'll touch on that in just a moment. But just focusing on Pennsylvania and what its statute provides for, a medical marijuana patient in Pennsylvania may not handle certain regulated chemicals. They may not operate high voltage electricity or public utilities. An example that would come to mind is someone perhaps operating a nuclear power plant control panel or something of that nature. Individuals who are operating up in a lift and fixing wires, that type of thing. And the Pennsylvania's law has a specific cutoff of 10 nanograms of medical marijuana, and really the only way to test that is through drug testing. Also, Pennsylvania's law has specific carve-outs that say a medical marijuana patient should not work in confined spaces or at heights. So these have important implications in the construction industry. A few more specific provisions in Pennsylvania's law give employers broad discretion in identifying positions as safety sensitive and allow a company to say, well, no, this job is safety sensitive, and if a medical marijuana user were allowed to perform it, it could create a life-threatening situation either to themselves or to others. So those provisions are all in there. Pennsylvania's statute also provides and understands that there are going to be unique situations and unique employers such as schools, correctional facilities, or youth developmental centers where there may be enhanced concerns about having individuals with, who are using medical marijuana in the workplace. You can think about that situation in a prison and how that could create a number of issues. So those are all carve-outs, I'll say, that are contained in the Pennsylvania statute and are important to understand in the depth and level of the protection afforded by the statute. Now, as my colleague, I'll try and make this short, Josh alluded to earlier, when I say that Pennsylvania falls in this second category of providing limited protections, many of the other state laws that were passed, especially New England states, Massachusetts, Rhode Island, Connecticut, also fit that model. They stated that they only protected employees solely based on their status as a medical marijuana user. And the presumption was that if you failed a drug test in the workplace, you could still be terminated. There have been a number of court decisions, however, in Massachusetts, Connecticut, Rhode Island, that have all said, well, that may be what our statute says, but we're going to go beyond that. And we're going to find that even if a medical marijuana user does fail a drug test, they're still protected, so long as they're not impaired in their work or unable to do their job properly as a result of their use of the medical marijuana. So the point of all that is that it's still unclear what Pennsylvania courts are going to do in that regard, and whether they're going to say that, no, you're only protected for your status as a medical marijuana user. So if your employer says, we're not hiring you because you have a medical marijuana card, period, that's unlawful. But we don't know whether the Superior Court, the Commonwealth Court, or the State Supreme Court are ultimately going to say, well, no, that's not enough. Under this statute, to really provide protections, you need to prohibit simply firing people for having positive drug tests as well. So I offer that as kind of the state of the law in Pennsylvania in terms of the employee protections, and to just highlight for council, the committee, that the end result really still remains to be seen on how broad this protection will be construed. Thank you.
I just wanted to add one thing from Mr. Vogel's comments. The statute talks about, under the influence, and there's only one instance which he touched on dealing with what under the influence actually means, and that's in the context of chemicals and high voltage electricity. You can't have any more than 10 nanograms of tetracannabinoids in your system. Now, I think what I want to explain, there's an important distinction that needs to be made because marijuana or cannabis has different components in it. One is the psychoactive component, which is otherwise known as THC. That's what these drug tests typically test for, and that's what's referred to in the statute. The other component that's in cannabis is called CBDs, or cannabinoids, and those are generally deemed to be those components that have the palliative care, pain relief, sleep relief type of qualities. And the issue is, I'm not aware, and Dr. Cohn can fill in the gap for me, but I'm not aware of any drug test that actually can test for CBDs. And so theoretically, I could have taken CBDs 5 minutes before I came into chambers here today, technically been under the influence, but no one would have ever known because of it doesn't give you the high effect as the THC would. And I think that's an important distinction to understand, because I think although the legislator did a nice job, it really opened up a door as to really what does under the influence mean.
Okay. Wow, I don't know where to begin here. Cut me off if I've overstepped my bounds in terms of time. I didn't have a formal presentation to present because I was just notified and agreed to participate in this panel. But there are many areas that were mentioned here, and I want to draw the focus, because my understanding was to discuss the aspects of the Medical Marijuana Act as it pertains to not just the employee, but also the employer. And under those circumstances, there are many aspects that were talked about today and need some clarity. Just by way of stepping back a moment or so, I'm a forensic toxicologist. Toxicology is a branch of pharmacology. Pharmacology is the basic medical science that deals with the actions and uses, or the wanted actions of foreign substances on the body. So pharmacology is the study of therapeutics. It's that medical discipline that deals with therapeutic agents. Toxicology takes it a step further, where it's concerned not just with the desired effects, but also with the adverse effects. And then forensic toxicology is a further sub-branch that deals with the detection, the measurement, the confirmation, and the interpretation of foreign substances in body tissues and fluids. And these fluids can these biologic specimens can either be from post-mortem specimens. I used to be a toxicologist with the medical examiner's office for Philadelphia for 8 years, or they can be from ante-mortem specimens, and I practiced in that realm for the last 30 plus years as a forensic toxicologist. I also am the author of the collectively bargained National Master Freight Agreement dealing with the Uniform Drug and Alcohol Testing Guidelines that was agreed upon between the International Brotherhood of Teamsters and the organized trucking industry. At some point after that was in the mid-'80s, and it was in effect for 5 years or so, and then the federal guidelines came in under the drug-free workplace guidelines. It took effect, I believe, June of 1989. We heard discussed today failing a drug test. If an employee or a pre-employment test is administered, the person can fail that test. I want to distinguish here between urine and blood, and what the Pennsylvania statute, as I understand it, versus, and you have to help me out here if I'm interpreting it in error, based on what it means to A, fail a test, and what kind of test is being done. In a pre-employment test, urine is used. A non-invasive test, in other words, you're not doing a venipuncture, drawing blood. You're merely obtaining the urine to test for a variety of substances, one of which would be marijuana products. In that urine, we are looking for the metabolite of marijuana, one of the cannabinoids. We're looking for the inactive metabolite, which is under the federal guidelines, which is tetrahydrocannabinol carboxylic acid. I'm just going to refer to it as carboxy-THC. The THC doesn't exist in the urine. THC is a fat-soluble drug. It doesn't want to reside in urine, which is essentially all water. So the species of the marijuana that you're looking for in urine is the carboxy-THC, the inactive concentration. But by the same token, nobody is under the federal guidelines anyhow, and in my opinion, what should be adopted by the council is that those guidelines are for the purpose of showing use. The part where you're referencing on this last slide where it talked about 10 nanograms per ml, and I think the exact wording in the Medical Marijuana Act is 10 nanograms of tetrahydrocannabinol per ml blood, per milliliter blood, then it says in serum.
Yeah, that's exactly right.
Right, so what does that mean? And I want to differentiate between the two types of tests that are going to be performed. From the standpoint of pre-employment testing or random testing, if that's mandated or it's utilized by a company, that would utilize urine, and the purpose of that test is to determine use, not impairment. So if somebody appears to be in a work environment where there are deficits that trigger a reasonable suspicion test, most people are going to do a urine test. Whereas under the statute, the way I see it written, is it actually gives you a value when it talks about blood, and I'm distinguishing, it says blood in serum, and I'm distinguishing there because if you run serum, you're going to have probably twice the level of the THC. In the blood, we look for THC and carboxy-THC. Urine, you're only looking for the inactive carboxy-THC. But the statute refers to 10 nanograms of the THC in serum. If you were to run the blood, that's going to have half the amount. Doesn't matter from a toxicological standpoint what specimen you run. If I run blood in a reasonable suspicion event where somebody is showing outward manifestations or some behavior that triggers an in-service test, according to the way I read the statute, the only way you can say that he's under the influence, quote unquote, is that you have to have 10 nanograms in serum or 5 nanograms in blood. So there's a difference between what happens under federal guidelines versus what happens in the, all right?
Yeah, no, Dr. Wood, you just raised an important point, and I'm hoping our attorneys can go back for us to the slide where you have serious medical conditions. If you could just go back to that slide. I would ask that we pay particular close attention to this. Of all of the serious medical conditions that must be diagnosed or are allowed, you are allowed to receive medical marijuana as a form of treatment, the one that is highly likely and most concerned to me as a member of council and a representative of the city is the issue of PTSD. And the reason why the post-traumatic stress disorder is extremely important is we have now, similar to what we have found relative to the discussion of opioids, right? That we have now, compared addiction to opioids as a public health crisis versus a criminal kamikaze that we reference the crack cocaine epic in the 1980s that ravaged, areas and communities like the one I grew up in West Oak Lane. PTSD right now, we are hearing doctors, medical professionals, social workers, educators, acknowledging that communities that suffer from a high rate of gun violence, child abuse, sexual assault, environments like this, that they are making a connection that trauma, that residents who have experienced these types of acts, whether it be gun violence, abuse, sexual assault, that they have been diagnosed as having PTSD. So when we talk about who could be diagnosed with PTSD, I know we were talking about, well, people with some of these diseases wouldn't be working in many industries that we would be concerned about, but I would dare say to you that there are people in the city of Philadelphia living in every neighborhood that you could think of who, if a doctor diagnosed them with PTSD because they were maybe impacted by something that I described, are forced to go to work every day and function in the midst of the trauma and the traumatic stress that they have, and they still have to function and provide for a family. So when we sort of talk about guidance that we're looking to you, the legal industry, the medical industry, to help to provide to us as a city to do what Councilman O'Neill so aptly described as making recommendations from our fact gathering that we conduct here in city to the Commonwealth as it moves forward. That's the lens through which we want you to think about our actions in a very practical, the nature of the response that we can see from the ground up. So when you think about PTSD, which I was happy you sort of went through all of the allowable medical conditions, that's the one for me that really raised the red flag. And wait a minute, from an education perspective, how can we proactively inform our citizenry of how they should move forward if in fact they become patients, and how it will affect not just our employees, but we're thinking about our business owners too. So if you could just, any recommendations, ideas, concepts do you think that we should sort of form here at the local level? Do we need to form an advisory committee that you all in the private sector, the legal community, along with the medical community, would be able to help us develop a guide of potential educational recommendations that can be used as a tool to, again, just educate residents in the city of Philadelphia, about, issues relative to this medicine that they should be concerned about, and any unintended consequences that will impact employers and employees that we should be, telling them that they should be aware of. Your comments and your thoughts.
Yes, Council Member George Vogley speaking again. I think that you raised an excellent suggestion that perhaps some type of an ongoing advisory body, panel, or just workforce within the Human Relations Commission may be of use and help. You're absolutely right. Many of these conditions that we're seeing are chronic conditions that unfortunately lead don't have a good outcome. At the same time, many of them, such as Parkinson's, epilepsy, glaucoma, PTSD, as you said, people go to work with them every single day in the city of Philadelphia. And so these individuals will need help and guidance in managing these conflicting legal requirements. And importantly, too, there are a number of different interested groups in this. It's of course the patients who suffer from these conditions and need it first and foremost. At the same time, you also have the public and their interest in safety and making sure that, you know, this may sound silly, but no one wants someone using or under the influence of medical marijuana driving their children's school bus or necessarily up in a cherry picker working on a power line. And those kinds of things are already baked into state law. So we have to balance those interests as well in public safety, along with employers' interests in making sure that they're complying with the law and at the same time getting the best out of their employees, giving them the best opportunities to do their best in their careers despite these conditions and having to work through them. So perhaps that type of a group or advisory panel would be very helpful in helping everyone navigate this issue.
And yeah, just to add on, Joshua Horn, add on to Mr. Vogel's comments, I think the issue has to be studied because it's, you know, PTSD is somewhat amorphous, and people, you know, one person may say it's PTSD, another person may say it's something else. But I think the important thing you have to understand is the statute itself provides for a special license called the clinical research license. And hopefully, what I hear, the regulation is supposed to be finalized by this weekend, and we're going to start that process. And so what the clinical research registrant license will be, there's teaching hospitals throughout the Commonwealth, and there's going to be a company affiliated with the teaching hospital, and part of what the project will be is to study and research the effects of medical cannabis on all these serious medical conditions. So my hope is, through that process, there will be some reporting, at least back to the Commonwealth, as to what are we really seeing? Can we treat PTSD with a CBD only so people aren't getting that high at work? Can we, or does it have to be treated differently? So that's the clinical registrant license. Now, there's an aspirational provision within the statute, which I'm not optimistic about, which is just a general research provision under Chapter 19 of the statute. You know, I think it's aspirational that the Commonwealth wants to have studies about it, but I think it's more likely you're going to get it through the private sector, through these clinical research registrants. And then there's an advisory board to the Department of Health. Will then have to report back to the Department of Health whether changes need to be made in the statute or additional regulations need to be made to actually specifically address some of these medical conditions if they need to be addressed in a particular way. So I think there is some infrastructure from a Commonwealth standpoint for ongoing study, but I do believe, you know, that it is something that we have to be looked at very seriously.
I want to go back and refocus on what the council can do in terms of employee protections and employer protections, because that's my understanding that was the focus of what we're dealing with here. None of us should be dealing with trying to interpret the medical conditions or evaluating a patient. An employer certainly shouldn't be responsible for determining whether or not one condition is going to be acceptable and another is not. That's in a different realm, and that's with other legal aspects. However, we don't have to reinvent the wheel. There are processes which mimic the federal guidelines that you carry over into the non-federally regulated areas. For instance, if employees should be protected against having their medical information disseminated to their employer, unless I think of one instance where under SEPTA, where they are required, if they're drivers, to notify the medical department prior to working whether or not what medication they are taking. Now, that's been in effect for a long time. I don't know what the legalities of that would be, but what we're dealing with here is in the private sector. What are the responsibilities of the employee? And to me, their medical records should be confidential, because just merely saying they're a medical marijuana user, they may have protections, but they could also trigger adverse effects, whether they're going to be employed or not employed, based on any of these other conditions. So I think that if they're going to be subject to a test, in other words, a pre-employment test, that the results of that test goes through a medical review officer, somebody who reviews the nature of the test. If it's a positive test, whether positive or negative, all results come from a medical review officer. That way the employer has no idea whether the person was positive or not. Let's take as an example in a pre-employment instance. If somebody tests positive for marijuana, the employer isn't notified. The employer is paying for the test, but he's not notified as to the findings directly from the laboratory. It goes to a medical review officer who then talks to the individual. If that individual has a medical marijuana ID card, to my way of thinking, under the Pennsylvania Act, that becomes an MRO, a medical review officer negative. The employer never sees that negative, that never sees that positive. That's no longer an issue. He has a medically documented reason for having that positive drug test. And let me say that in those urine tests that are being performed, whether it's an in-service employee or a pre-employment, we're not looking for the last molecule of marijuana, of carboxy-THC, the metabolite in the urine. There are cutoff levels, threshold levels that must be reached, and you have to work on those. However, I think under the Medical Marijuana Act, the fact that that's going to be legal for these individuals to have access to the marijuana, virtually all of those are going to test positive on a urine test because they're going to be taking it chronically, day in and day out. And I mean, you hear these stories where marijuana stays in the body for 30 days and so on. Stays in the body for a lot longer than that. But we're not looking someplace in the body. We're not doing a fat biopsy or taking a liver biopsy. We're looking in the urine. And you have threshold values, and probably you're dealing with days, 3 days. But I would tend to think with chronic medical marijuana use, you're going to have a longer window to see the positive findings. But if there is a positive finding, the medical review officer interviews the individual. If there is a legitimate reason, and according to the Act, if there is a, whatever that term was, the medical marijuana identification card, if that's present, that becomes a negative to the employer. So no action, no adverse action is taken against that employee. By the same token, it protects the employer because he's out of the situation of deciding, do I use this as a reason to discharge or don't I use, or not to hire? And it's no longer a situation where he's making a medical consideration or abusing the rights of the employee. So I think there's a win on both sides. When it comes to the in-service individual who's pulled because of the under the influence designation in the Act, that's the only reason that I see where the person can be terminated or action can be taken. The legislature has actually given a definition, whether it's right or wrong, it's probably wrong, but whether it's right or wrong, they've given a definition of what is under the influence. And what is under the influence is 10 nanograms per milliliter, 10 nanograms of THC, tetrahydrocannabinol, the active constituent, per milliliter serum. So that would also go through a medical review officer, but that's a no-brainer because that's established. Those values, the medical review officer has no right under the Pennsylvania statute to overturn that 10 nanogram or higher value. So that's my 2 cents worth so far.
Thank you, Doctor. And we'll ask the panel, and I'm going to ask again if you all could just come up because we don't want you to leave while our next 2 members are testifying. Then Councilman Dom, no, please don't move. We'll just ask the other 2 to move, yes, and you'll share microphones. Thank you. Thank you, Councilman Dom.
Thank you, Madam Chairwoman. And I had 2 questions that very simple answers to these questions. One is for you, Dr. Koenig. The other question will be for Mr. Vogel and Mr. Horn. Dr. Koenig, I just want to make sure I understand what your testimony was saying. You were talking about 2 types of tests, a urine test and a blood test. And I think what I learned is that the blood test is a much more accurate test than a urine test. Is that accurate?
No, they're both accurate.
Both accurate.
They're both accurate. It's what they tell you.
Excuse me, Doctor.
I'm sorry. They're both accurate tests. The accuracy is not in question. It's what they indicate or what they tell you.
Okay, so does the blood test indicate impairment while the urine test does not, or is that not true?
No, you're absolutely correct. It's the same thing as driving under influence cases in a criminal situation. The statute, if you're driving a motor vehicle, doesn't say that you cannot operate a motor vehicle if you have a 0.08% urine alcohol concentration. It says blood concentration. So blood allows one to determine whether or not there is a circulating level of the drug sufficient to cause impairment, whereas urine, that's been removed from the system, it's trapped, yes.
So in your opinion, doing the blood test would be much more accurate and better results and more information than a urine test?
Yes, but it should be reserved only for reasonable cause cases because of the expense and the venipuncture, the fact that you're drawing. You don't want to be drawing thousands or tens of thousands of blood draws indiscriminately. So the urine is, as I said, the urine is used to determine use in a pre-hire situation. If there is a use of the drug, that's determined by the positive urine test, and there is no medical documentation, there's no medical marijuana identification card, then that becomes a positive. The positive is not turned around. If there is a legitimate reason with that medical marijuana card, then that positive test becomes a negative to the employer. The medical review officer reports to the employer a negative finding, even though it was there. So the accuracy is there. It's just that you can't use the urine to determine impairment.
Okay, thank you. My second question is for both of our attorneys at two very good firms that the city has, by the way. And my question is, based on what you've heard and based on what our Madam Chairwoman would like to see come out of this, I think this is, which is a guide, basically. If I was one of the companies in Philadelphia and I called your firms and said, can you give me a guideline as to how to deal with this issue? Is that currently available from either of your firms that you provide?
So, Councilman, our firm prepared a white paper that laid out some of the basic parameters of the law. I think we may have updated it at some point. I don't know that we have anything that's as comprehensive or in-depth that perhaps the committee is considering now. It was more along the lines of, hey, these are the new requirements, you should be aware of this, and if you need help complying with it, give us a call. But that's, I believe, as far as we've gone in terms of explaining it to our clients, and other than that, it's been advising individual companies in their unique situations given their workforces.
And our experience is consistent with Mr. Vogley's firm, and what we've been focused on, for example, companies that have policies, drug statement policies in their employee handbooks, we've been revising those issues to take into account, number one, that you can't discriminate. But at the same time, one of the gaps that's in the statute is you can't discriminate, but it doesn't say anything about if you have a mandatory zero-tolerance drug test, that you hire them on day one, you give them a drug test on day two, you fire them on day three. I mean, that scenario is unfortunately existing.
Well, let me ask this question. If I'm going to, as an example, if Comcast or ARA or University of Pennsylvania called either of your firms and said, we'd like to develop a policy on this issue, what would you provide them with?
Well, I think what we'd start doing is look at what policy they have in place, and then look at what's in the statute and try to frame a policy consistent with what the statute provides, based upon our interpretation of the statute. Unfortunately, in my opinion, I think ultimately judges will be deciding what that means. Because I think the statute was written open-ended in a sense because there's so much uncertainty.
So I guess my question really is there any background information that either of your firms have or know of other firms or the Bar Association has that you can just share with our chairwoman for this committee to help formulate this guide?
I'm happy to look into it.
Yeah, we could certainly look into it. I know that various law firms and chambers of commerce have notified their constituents or their clients about this law. I don't know how comprehensive, though, the other providers' notifications have been beyond my own.
Okay, thank you very much. Thank you.
Thank you.
Councilman Toppenberg. Wait, excuse me, Councilman Toppenberg, before you start, Councilman O'Neill, relative to the bill that was passed prior to the public hearing on the resolution.
Yes, that bill was reported out before I arrived here, and I'd like to be recorded as voting aye on bill number 180012.
Thank you, Councilman O'Neill, and the record will reflect
Thank you.
your affirmative vote. Councilman Toppenberg.
Thank you. You had just said that you thought the state law was open-ended and very vague. That's difficult, and I can see great difficulties here. But I just wanted to ask you, in your opinion, what could they do, the state legislature, to tighten it up?
Well, and I'll use what does it mean to be under the influence? And so there is a definition for under the influence if you're in the chemical industry or you're operating with electricity. One way to tighten it up was you define under the influence, whatever they define that to be. If it's going to be 10 nanograms of THC in the blood serum, then that's it. But I think that would be one way to at least close that gap. It'll still be an issue because, as Dr. Cohn said, it stays in your system for quite some time.
Right.
And if you're a heavy user, with people who are suffering from one of the serious medical conditions, so that you could have a very high level of THC in your blood and not be high at work. And so, but I think, there's only so much you can do, and I think if they define really what under the influence means, that'd be a step in the right direction.
So,
I just want to
go ahead.
clear up one thing. Marijuana.
Dr. Khan, the stenographer is giving me the eye. Thank you.
Sorry. The THC does not stay in the blood for a long time. It's relatively dissipates relatively faster. It's sucked into the non-water compartments of the body, and small amounts will leach out. We probably by the routine methods detect it for maybe 5 to 7 hours or so after its last use. The caveat is for somebody who's taking it chronically day in and day out, there may be longer periods and higher levels. Once again, I believe that anybody that has a medical marijuana identification card is using it chronically, he's going to test above that 10 nanogram value no matter what, even though the levels have dropped. The important factor that the employer has to consider is that if they're going to pull an exam, if they have reasonable suspicion to have an employee looked at, to have him tested, because they feel he's under the influence. Well, I think one of your slides had said, how will the employer know that it's 10 nanograms? You're never going to know, but the test is what proves it. But if you're going to pull that individual, the time to do it is immediately and not wait and not bring other people in to say, what does he look like? And maybe I should do this or maybe I shouldn't, because those levels are falling. However, like I said, with a person who's taking it chronically with a medical marijuana identification card, that person, I have a feeling that no matter what, he's going to test positive in a blood test, in a reasonable cause blood test, reasonable suspicion test.
Madam Chair, thank you.
Thank you. Thank you so very much. And I hope we're not holding you, but I do want you, if you will, to just remain seated while we ask panel 3, Mr. Mike Lee from the DA's office, along with Ms. Samaria Harris, to give their testimony, because I think responses could potentially overlap. And we can start with Mr. Mike Lee from the District Attorney's office.
Thank you, Chairwoman Parker, and thank you to the Labor and Civil Service Committee for inviting the District Attorney's Office to testify here today about such an important matter. Specifically, the District Attorney's Office is asked to testify about the status of individuals with convictions related to marijuana and their ability to work in the medical marijuana industry, and secondarily, how we as law enforcement may handle cases with visa holders, DACA recipients, and undocumented immigrants as it relates to medical marijuana. To the first point of people with convictions working in the medical marijuana industry, the Act, as I understand it, defines 3 basic categories of industry employment. The first would be that of a doctor, and the statute is, or the Act, excuse me, is silent as to if a prior conviction for a controlled substance will prohibit a doctor from entering into the training program to become certified as a provider. I would imagine that some of the other state licensing requirements around practicing medicine would include some type of drug testing or other protections for the public, but as it relates to the Medical Marijuana Act, that category of employment is silent as to prior convictions for marijuana. The second category would be that of a caregiver, which is a person authorized to pick up marijuana at a dispensary or administer it to a registered patient. Those individuals, the department, and I'm quoting the act here, shall deny the application of a caregiver who has been convicted of a criminal offense that occurred within the last 5 years relating to either the sale or possession of drugs, narcotics, or controlled substances. The department also may deny, meaning they have some sort of discretion, an application if the applicant has a history of drug abuse or of diverting controlled substances or illegal drugs. So essentially, if you are applying to be a caregiver for a medical marijuana recipient, a conviction within the last 5 years shall prohibit you from getting your caregiver's license. It is unclear if that is 5 years from the conviction date, 5 years from the offense date, or 5 years from the end of supervision, all of which would be different moments in time of when the clock would start ticking. The third category of employment, as defined by the Medical Marijuana Act, is a very large catch-all called medical marijuana organizations. And that would include growers of medical marijuana, processors of medical marijuana, and medical marijuana dispensaries. In this instance, convictions come up very broadly. Essentially, you may not volunteer or hold any compensated position if you have a conviction for the sale or possession of illegal drugs, narcotics, or controlled substance. There's no time limit as to how old a conviction can be. That would allow even discretion for the board to grant a permit to an organization or individual employee, and that would include financial backers of a dispensary, processor, or grower of medical marijuana, principal officers of those three, or employees. So I think that would cover everyone from someone who's driving a truck to and from a dispensary, someone selling or providing or dispensing medical marijuana in a dispensary, up through a financial backer of a medical marijuana organization applying for a permit to grow marijuana. As that relates to the residents of Philadelphia, it's a little difficult for us with our current technology to discern a couple things within our data. First and foremost, we have to consult separate database to look at arrest information compared to convictions. So it took us a little longer to focus in on how can we identify convictions. We still haven't quite been able to parse out if someone is a resident of Philadelphia when their conviction occurred, or if they were visiting, or correspondingly if they're a resident with a conviction from another state. Another very important barrier that we discovered is that the racial data and identification is usually determined and assigned at time of arrest by an arresting officer. So it can be self-disclosed where an officer asks an arrestee how they identify themselves, but from what I've been able to gather more often than not, that is just what the officer believes someone's race to be. They do not follow the racial categories as defined by the census or anything else. So we actually don't really have good information on Hispanic as a race. With that said, I can tell you that we looked back over a 5-year period from 2013 to 2017 to see under the caregiver provision how many people would be allowed to be a caregiver if the 5 years goes from the time of conviction. And we found, looking at just marijuana arrests and not all drug arrests, so these numbers would grow probably exponentially if we were to include other controlled substances, but looking at just marijuana, there are 1,455 African American women with a conviction for some type of marijuana offense, whether it be small amount of marijuana for personal use, if they were picked up as a buyer during a sting operation to get someone who was selling marijuana, or as a marijuana seller. That is compared to white women, which came in at 498 convictions, and by far the largest group is African American men, which is 11,946 convictions for some type of marijuana-related offense, compared to white men, which would be 2,811. So even with our preliminary information, we can see a very disproportionate impact on African American men as it relates to marijuana convictions. In fact, I was playing around with the numbers, and you can add up the top 5 other categories and still not come close to the total amount of convictions for African American men for marijuana-related offenses. Conversely, diversion programs are offered substantially less for African American men than any other group. In fact, it's the only group where diversion is below 30%. So every other demographic, racial demographic we were able to analyze had at least 30% of marijuana-related arrests going into some type of diversion program, but not only 26% for African American men. We can't really speculate as to why that was historically, but some of the policy changes that we've made since January, we hope to impact and change that drastically. Specifically, the biggest change as it relates to this question is the District Attorney's Office since February 1st has ended the practice of prosecuting small amount of marijuana cases. They were making up, I think in 1 week we had 51 arrests for small amount of marijuana, and about a third of those were going through diversion, but the rest were going to go through our traditional trial system and take up court resources, and the district attorney doesn't believe that small amount of marijuana should consume the same amount of resources as other types of misdemeanor offenses within the city of Philadelphia. Another thing that we're doing is expanding access to diversion programs to include more marijuana-related offenses, but that's a dual-edged sword. What we're trying to do is get more marijuana offenses out of treatment court and drug court so that we can free up treatment beds and other resources that are available in treatment court for people with different types of substance abuse issues. So for example, someone who might have an opioid issue would be competing with someone with a marijuana abuse issue for bed space if they were in the same treatment court program. So moving diversion of marijuana offenses from drug treatment to other forms of diversion like accelerated rehabilitative disposition or ARD, we hope will continue to allow us to help people who need services for other types of substance abuse and increase the number of diversions as it relates to the sale of marijuana, where we've already said possession, we're not going to prosecute, so there's no reason to divert. For the second question that we were asked concerning immigration or visa holders, DACA recipients, and undocumented immigrants and medical marijuana, it's very important to remember the federal-state distinction, and it plays out very much in the immigration context. I believe the immigration takes a similar stance as our state police, which followed alcohol, tobacco, and firearms, and the analysis is that an unlawful user of or someone addicted to any controlled substance doesn't have the character or standing to own a firearm. So therefore, if you have a license to carry a firearm, you should consider that against your desire to get a medical marijuana card, because once you get a medical marijuana card, you probably will have your ability to carry a firearm revoked because receiving treatment is viewed as having an addiction as it relates to this federal law and the interpretation by the ATF. For someone who is not a citizen, any citation or conviction for marijuana possession or sales can trigger removal proceedings for undocumented immigrants and those living with visas or on temporary status. In some cases, a citation or conviction for marijuana possession can also trigger removal proceedings for a lawful permanent resident. Any admission to immigration regarding the possession of marijuana, regardless if it is legalized or medically approved, it can trigger removal, denial of admission. And this includes on a naturalization application. If an immigrant is never cited, arrested, or admits to the possession, then there may not be any type of consequence for it. But we have seen anecdotally an increase in immigration officers asking people about marijuana use, and people are volunteering, particularly in states where it's legalized recreationally or medically. Yes, I use marijuana, which can therefore trigger removal proceeding. The same would be true almost de facto by having a medical marijuana card. That would imply that you are using or possessing marijuana and could therefore trigger removal proceedings. And I think something that took me back some was that even if you were employed in the medical marijuana field, so let's say I had a job driving marijuana from the grower to the dispensary, under federal law, I could be considered a drug trafficker, and that could be grounds for my removal, even though it's a lawful activity and employment in the state in which I was doing it.
To hear your testimony. We want to get to your testimony, and I think if we really do start with our questions, I mean, it's just going to be just a second. That's why it was important for all of you to stay. Why don't you give us your testimony, and you put a pin in everything you just said.
Thank you so much, Chairwoman Parker and members of the Labor and Civil Service Committee. My name is Samira Harris. I'm a registered nurse in the Medical Intensive Care Unit at Einstein Medical Center, Philadelphia. I'm also a member of the Executive Board of the Pennsylvania Association of Staff Nurses and Allied Professionals, and on our local Einstein Nurses Union. So I'm here from the perspective of the labor force and from the employee perspective of this. As a medical professional, I support the medicinal use of medical marijuana for patients that are in need. However, I do have some concerns about how employers may handle employees who are also medical marijuana patients. For example, PASNAP has thousands of members, and it stands to reason that some of them will be medical marijuana patients. I think I can personally identify nurses that have at least 4 or 5 of those medical conditions listed on that board that I know. PASNAP members work for hospitals and other institutions that employ drug testing upon hiring and on a random basis after hiring, and that's with good reason. A medical professional should never be at work while under the influence of a prohibited substance. However, what about the medical professional who's also a medical marijuana patient and only uses medical marijuana during their off hours? Additionally, as the doctor stated here, we know that the mere presence of the metabolite in one's urine does not equate to impairment, and the drug tests don't distinguish whether one consumes an hour ago or 5 days ago. What our employees are going to do is, what are our employees going to do if their employees test positive for marijuana, but said employee is a medical marijuana patient? What protections do we have in place for employees who are medical marijuana patients? I know at my organization at Einstein, which I actually think is represented by Fox Rothschild, we have no protections in place as of this moment. It's because of unanswered questions like these that I applaud Councilwoman Parker for holding this hearing on medical marijuana's potential impact on employers and employees in Philadelphia. Now that medical marijuana is being rolled out, it's imperative that we get some of these questions answered before these hypotheticals I just described become a reality. Thank you so much for having me today.
One, I want to thank both of you, Samaria, along with Mike, for your comments. I want to go back to one. I wanted to make sure I noted this, and I want to get this on the record. I'm reading an article that was dated February the 1st, 2018, and it was from NBC 10, and it says Philadelphia Rep. Jordan Harris, who is also the chair of the Pennsylvania Legislative Black Caucus, introduced a bill to automatically expunge cannabis convictions for medical marijuana patients in Pennsylvania. And Representative Harris is quoted as telling NBC 10, it will be for anyone with a medical marijuana recommendation. So I wanted to note that for the record. I wanted to come quickly, if I can, I'll come back to it. I'll find it and come back to it. I wanted to ask you, Mike, and I wanted you to help explain it as simply as you possibly can. If I, according to the law as enacted by the General Assembly, if I suffer from one of the serious medical conditions listed and one of the physicians authorized to prescribe under the law prescribes me medicinal marijuana, if I have a caretaker, so now I'm very practically going into the homes, and I'm particularly thinking of mothers and fathers, aunts and uncles who are now being cared for by a relative who is considered to be their caretaker. Much like home health aid workers, we even see advertisement on television now that, when I was in the General Assembly, we're encouraging people to age in place at home, to not necessarily go to a nursing home to live out their golden years, but to stay home. And now firms have structurally made it possible for your daughter, your son, niece or nephew who can work as your caregiver at home. Are you telling me now that if my selected caregiver, and I'm just thinking if it's my son or daughter or niece or nephew, and I select them, they are my caregiver, and I'm prescribed that they cannot be my caregiver or get my prescription if within the last 5 years they happen to be one of the 11,946 African American men who you said were convicted for some, I don't care if it was a small amount or usage of marijuana, or one of the 1,455 African American women who you mentioned, they are not eligible to serve as my caretaker?
First, the statistics I gave you are for conviction totals.
Convictions.
So it is possible that one person could have multiple convictions, and we're not quite able at this point to discern if someone has repeat offenses, but we hope to provide that information. More specifically to your question, I believe that is correct. You would not be able to designate that individual as your caregiver in the context of them being able to go to a dispensary, show their caregiver authorization, the prescription that you would have as the patient, pick up marijuana, transport it, and administer it to the patient.
So again, I know it may sound like I'm beating a dead horse here, but I just want to make sure the message is clear, and others on the panel, if I am describing anything that is not accurate, because I know the public will be watching this hearing. If I have a son or daughter or a relative or someone who is my designated caregiver because I have one of the serious medical conditions listed here in this PowerPoint, and they were convicted, I think you talked about like a small dosage, small use, they were convicted. Correct. Even if it was small use, they cannot go and get my prescription filled for me and come back to administer it to me, even with one of the diseases that are listed here.
Correct. So if you are, and there's no restriction on prior convictions to be a patient and receive medical marijuana as treatment, right. Which is good. Right. But if you are homebound and your primary caregiver is a close relative and you want them to be authorized to pick this up and not be violating state law for handling marijuana illegally, then they would have to get certified by the state, and that certification would not be allowed if they were convicted of small amount of marijuana possession within the last 5 years.
Yes. And just to pick up on that point, so there's
Identify yourself.
Joshua Horn, for the record. So just to pick up on the point, the statute is pretty specific on what a caregiver, how you get a caregiver. And so when you as the patient apply to be certified in the program, you would also include that in your request for certification. And so then if the caregiver is disqualified for some reason, then it doesn't necessarily disqualify the patient from becoming a medical marijuana recipient. It just disqualifies the caregiver. And the statute is clear about the criminal component. If the panel wants to look at it, it's section 502 and 507 of the statute talk about the caregiver's qualifications, and then when caregiver limitations on caregivers, so that you have that for the record.
Councilman Dom?
Thank you, Madam Chairwoman. And this question is for Mr. Lee. I want to make sure I understand what you said about the change in policy at the district attorney's office. I think you said as of January or February, the policy has changed. Can you just explain that to me briefly?
Correct. The district attorney's office since February has declined prosecution when small amount of marijuana is the lead charge, and we decline prosecution on that particular charge if it's incorporated in other offenses. So if you're arrested and the only reason is that you had a small amount of marijuana, which statutorily is defined as 30 grams or less, we will not prosecute that case, and we hope that the police department will issue a civil citation in lieu of making an arrest and fingerprint. If there are other offenses that the police officer believes is taking place as well, then the office would still consider bringing those charges, but wouldn't necessarily bring the charge of small amount of marijuana or persons not to buy controlled substance, which is the statutory language for if the police are watching a drug dealer, in order to confirm that that person was selling drugs, they'll usually try to arrest 2 or 3 buyers to say what was an unknown leafy green substance turned out to be marijuana when we took it from this individual.
What is the amount that's the threshold that's considered a small amount?
Statutorily, it's 30 grams or less.
And the other question I have is, right now, our prison population has reduced up on State Road with the 6 prisons we have from 8,200 down to 6,100 with the MacArthur grant and all the great things we're doing. How many people do you think we currently have of the 6,100 that would not have been arrested if that policy was in place?
Man, using the 51 arrests in 1 week that we were able to identify in late January, I would times that by 4 and say 200 people a month were being arrested and charged with small amount of marijuana. I don't know what the prior bail guidelines would call for in that instance, so it's a little difficult to say with any certainty, but that's definitely something we can look into.
So let me ask you this question. If we arrested somebody in December of 17 under the old policy, but they committed the same exact crime in February of 18, they would have gone with a citation maybe in February of 18th and not gone to prison. Can we find out how many people are currently up on State Road under that would not have been arrested? And is there a way, I don't know the legality of this, to free them basically based on this change of policy?
Yes and yes. We are currently going through the last few months to see if there's any ongoing cases where we still have an opportunity to withdraw petitions, and we're looking into ways to notify people who are still within the appeal period to say, you had this small amount of marijuana conviction, which is graded as a misdemeanor in Pennsylvania, and just to give some context for the full collateral consequence of that type of misdemeanor conviction, it would be a permanent bar from jury duty if you have a small marijuana conviction. So what we're trying to do is identify as many of those individuals as possible who haven't been convicted yet to withdraw prosecution, as well as seeing if we can identify other individuals who are still within their appellate right so that they can appeal and then we can withdraw prosecution at that point.
So there's 2 points here that I want to bring up. One is, if we can do that, I'd like to see what we can do about getting their records changed or cleared or improved based on this new policy, or expunged or whatever. And 2, I just want to bring to light that the costs of the prison system is currently, with fringe benefits, because we never count that, $370 million. We've gone from 8,200 to 6,100. That's a 25% reduction. Our prison budget hasn't changed, by the way. In fact, it went up $4 million in the last budget hearing. And now we're averaging $60,655 per prison, per person, per year, or $166 per day, or $5,000 per month. So if we're at 6,100 now, we're supposed to go down to 5,500, and you're going to find there's 500 or so people, whatever the number is, we can get down to 5,000. We can start really seriously closing 1 or 2 prisons, which, by the way, at a time when we're talking about raising taxes, there's a tremendous amount of money. If our budget's 370 and our prison reduction is 35%, I would challenge the department to cut 15% of that budget, or $50 million a year, which is $250 million over 5 years. That's $250 million of what the mayor needs of 900 is a big piece of what we need to save. And the savings should occur. So if you can help with helping the situation, identifying how many people are currently on state road that would have not have been there under this new policy, I'd like to work with you, and I'm sure our chairperson will too, to get them out and back into society cleared.
Absolutely. And to respond to that excellent point, first, we also, when we identified those 51 cases, we've also contacted Philadelphia Lawyers for Social Equity and the Defenders Association to try to figure out a way to also alert those individuals of their right to an expungement. It's a little awkward for the district attorney's office to bring forward that motion, but we've made it clear that we won't oppose the expungement of those charges in particular, but more generally a broad view. Another policy implementation that we have done that we don't quite have the same control over is we are recommending that positive test for marijuana not violate somebody. And I think a lot of the population that we might see impacted by use of marijuana in state prison or federal prison or county jail, is as a result of a violation of a condition of supervision and not necessarily a new arrest or the existing arrest for marijuana only. So we are looking to see how many of those individuals could be released but for the violation based off a positive test. And I think it'd also be interesting to see what that department's policy would be for medical marijuana recipients and positive drug test for probation or parole.
How long will it take for you to give us some sort of an estimate of how many people are currently on state road that could be released?
Since it took us about a week to get this information, I would say it should take us about a week to get similar type of information. And if it doesn't look like it will happen, then I will contact your office and
Okay, thank you.
just
Thank
let
you
you
very
know.
much. I appreciate it. Thank you very much. Thank you,
Thank
Madam
you.
Chairwoman.
Listen, thank you to members of this panel. I just for the record want to note that what we hear, those loud voices, advocating fervently and passionately for what they believe in are students from our region who are participating in the national school walkout for gun reform and reducing gun violence. They are outside marching, and so I am, when I heard them, it was like hearing a baby crying. Councilman Dom, those were activists there, and we're excited. Let me just say, for the record, I want to thank each and every one of you, and I just quickly want to go through these names again for the benefit of not just those who are here, but for the public who are watching. We want to thank Yvette Nunez, VP for the Chamber of Commerce, Pedro Rodriguez, who is our Director of Human Resources here in the city, Rue Landau, McDowell, the Executive Director for our Commission on Human Relations, George Vogely, George Vogely, who's a member of Cozen O'Connor's Labor and Employment Department. Joshua Hearn, he is the co-chair of Fox Rothschild's Cannabis Law Practice and a member of the Philadelphia Bar Association's Medical Marijuana and Hemp Committee. Dr. Richard Kahn, a forensic toxicologist with DrugScan, and those very trying statistics and that data that you heard came from a gentleman named Mike Lee, who many of us, if his face is familiar to you in the public who are watching, although he is here representing he's Assistant District Attorney and Interim Director of Legislation and Government Affairs for our Philadelphia District Attorney's Office. You know his face because long before issues of expungement, criminal justice reform sort of, came bastions for people to publicly advocate for, Mike Lee was advocating in that industry long before it became popular, and we just wanted to note that for the record and talk about what an added value you are to District Attorney Krasner and his team. And to Samaria Harris, ICU nurse at Einstein Hospital and a board member for PASNAP, the Pennsylvania Association for Staff Nurses and Allied Professionals. To hear you, as our attorneys, sort of put up the serious medical conditions for which the use of medical marijuana is allowed, and to hear you in your testimony note that you can know of a few people who suffer from at least 3 to 4 of those who are actually working nurses right now in the nursing industry, in the medical industry, who could be impacted by the unintended consequences associated with this law. I think you affirmed for us just why we needed to have this hearing and to begin this discussion. I also want to give credit where credit is due and say a special thanks to a lawyer I've never met, but it was an article that he actually published that I read in the Legal Intelliger. His name is John McCreary. He is a lawyer at Babs and Callan in Pittsburgh, and in that article he wrote, "The imprecision of the Medical Marijuana Act statutory language addressing employment injects needless uncertainty into the employer-employee relationship and will likely not be resolved absent litigation." It was reading that article and that quote in particular that raised the red flags. We were dealing with this issue from another perspective, but we thought about the unintended consequences associated with employment in an industry that, adds value, has positive externalities for people who need this support. But how could we in the city of Philadelphia be proactive in using our platform to educate and inform, or developing a formal process whereby we inform our residents along as they learn to live in the realm of Pennsylvania's new law. So I want to thank each and every one of you for your testimony. You have married to us on this issue now, so rest assured, council will not be attempting to make any recommendations to the state, or I will not be recommending, or any other committee members for labor and civil service, making any recommendations to the state or on the development of any guidelines, even relative to employment, if we have not called you all back who've added value to our hearing today to ask you to be a part of helping to guide us as we move forward. So we want to thank each and every one of you for your participation. And Councilman Taubenberger has some comments.
I just wanted to say and reiterate what the chair lady has just said, Chair Lady Parker. I really want to thank you really for your time, which I know is valuable. I found all this very, very, very informative. And the time you spent here, I know you had to wait some time as well, and the time that you were at the witness table was very productive in my end, and I do greatly appreciate you being here. Thank you.
Thank you. Thank you all again. Also, we just want to note before we close, our focus was very much on unintended consequences associated with the medical marijuana law and its impact on employees and employers. It was not until your your testimony, Mr. Lee, that you also just raised another flag for us relative to the negative unintended consequences for people who are highly likely and or probable to have someone or may be considering someone to serve as their caregiver and who needs the support but may have been impacted, or have a previous conviction, particularly for the small dose that you've actually stopped prosecuting here in the city of Philadelphia. But you make us think, how many residents of the city of Philadelphia have one of those serious medical conditions, are under the care of a physician who's certified to prescribe, but don't have anyone close to them or near them, or they even know, maybe they could call someone at PCA, maybe they could call a social worker. I'm sure there are options, but we're in government and we sort of think that way. The average Philadelphia citizen just may not. So we have to, in our minds, sort of figure out how we work through that maze in the delivery of that service. So there is, no discrimination in those who are having access even to the medication that has now become legal in the Commonwealth of Pennsylvania and could benefit residents of the city. So thank you all so very much. We look forward to working for you, and that concludes this hearing for City Council's Committee on Labor and Civil Service. Thank you all.
Thank you.
First, my regards to